Hi, good morning. I'm Daryl Cartwright, an attorney in Birmingham, Alabama, and I wanted to talk with you today about what happens if I get sued. If I get sued individually or my business gets sued, what do I need to do at that point? I'm not going to attempt to provide an overall comprehensive guide on how to defend a lawsuit, but I wanted to harp on a couple of very important points of what to do and maybe more importantly, what not to do. You've been sued. Don't panic. It's just an opportunity for you to present your side of the dispute and perhaps work something out favorably in litigation. Number one, contact your attorney. If a lawsuit's been filed, more than likely it's worth contacting an attorney to defend. Uh, the lawsuit, once it is served upon you, must be responded to within a short time frame. And so contacting an attorney right away is very, very important. That time frame may be as little as 14 days in state district court to 21 days in federal district court or up to 30 days in state circuit court. But if you fail to respond, you may lose your case by default. If you file a responsive pleading, and when I say responsive pleading, that's usually an answer, but not always. It could be a motion to dismiss, or maybe it was filed against you in the wrong court and a motion to transfer is appropriate. Any of those things can be evaluated by your attorney. Moreover, you may have what's called a counterclaim that is required to be filed in that lawsuit. It's known as a compulsory counterclaim. And if you don't file your counterclaim in that lawsuit, you may lose your rights to pursue whatever claims you have against that other party. So a lot of very important things are going on right away, and things that you need to make sure that you address before you let too much time go by. I would tell you, certainly if you're represented by counsel, do not contact the other party. Even if they are a former employee or a customer or somebody like that, don't talk to them directly. Let communications go through your legal counsel. If, however, you're going to not follow my advice and you're representing yourself, certainly somebody needs to be in contact or can be in contact with the other side and possibly work something out. Uh, if you work something out early, that might be to everybody's benefit. There's an old saying that even a bad settlement is better than a good trial. And what that means is that the litigation process can be expensive for the defendant. And as a result, it might be in your best interest to work something out in settlement, even if you're in the right. Just consider that very, very carefully. Now, if you do work something out, and again, if you've ignored my advice and you are representing yourself, make sure you have still responded to that lawsuit. And this is very important. I have seen time and time again someone think they've worked it out with the plaintiff. They think they reached a settlement. They don't think they have anything else to do. Well, lo and behold, nothing was done in writing. Nothing was signed off on by both parties. In order to have a settlement, both parties have to agree. And as a result, they didn't file their answer, and the judge issued a default judgment against them. It turned out that they ended up being liable for much more than what the settlement would have been. So make sure that you have that responsive pleading, that answer on file before the deadline, even if you have worked something out. If the case has not been dismissed, you need to have that answer on file. Hopefully you won't be sued, and all of this is just an interesting academic discussion. But if you are sued, make sure you protect your rights. Call a lawyer, call me, be glad to talk to you. You have a great rest of the week. See you next time.